Mr. Wernick, when you were clerk of the Privy Council, you oversaw compliance of the Conflict of Interest Act. Would you say that the existing divestiture provisions, including the use of blind trusts, actually prevent conflicts of interest, or in practice, do they or can they fall short?
I think this is probably one of the central questions the committee will want to come to a view on. If you'll just permit me, I saw the conflict of interest regime as one tool in a broader toolbox about democratic governance, and there are a number of tools designed to detect and deter inappropriate points of leverage on our decision makers and keep the trust of Canadians. So very briefly, the Lobbying Act, the rules around campaign donations, the Foreign Agent Registry, security clearances, the criminal code provisions. This is all helped by a beneficial ownership registry, a lobbyist registry, and transparency around government contracting and contribution agreements. Parliament created the commissioner model, and it provided for a range of remedies at the discretion of the commissioner, and one of them is a trust arrangement. So I think it's up to you to judge whether it falls short or not. I would keep it in the toolbox.
Would you say that it's effective for people who report to the Prime Minister to be the ones ensuring that the Prime Minister that they report to is not in violation of the Act?
Well, it's ultimately up to the commissioner to make rulings on that.
To make rulings on whether or not the people who report to the Prime Minister should, for example, administer a blind trust?
No, correct me if I'm wrong, but if the arrangements that any Prime Minister or Minister or office holder would make would be discussed with the Commissioner, and the Commissioner would exercise an opinion on whether they're adequate or not, can request changes and has remedies available to him or her.
Based on your experience, do you think that that works?
I think that it's going to be tricky when people come into a background, extensive background in the private sector. People come into Parliament, as you know, from many, many different backgrounds, and we want, I think one of the other purposes is to ensure broad and inclusive participation in public office. I would be very careful considering mandatory divestitures because it may end up as a deterrent to people with a private sector background coming into politics. And my view is that we need more people with private sector backgrounds in politics, not fewer.
I guess the issue is that it's a question of public confidence, Canadians being able to trust that the system that's in place is adequately ensuring that there is no conflict of interest. And in the case of an individual entering office, being elected, serving as Prime Minister, having significant investments, and those investments going into the blind trust, and the Ethics Commissioner telling us that there's not any really a lot of churn of those investments, they know what's in there. And then the conflict of interest screen is administered by direct reports to the Prime Minister. And the perception can be and is that there's a conflict, and that a Prime Minister is continuing to take decisions that further their own financial interest. And there's no reporting to the public on when a conflict of interest screen has been triggered and if it's ever been triggered. And so the higher imperative, I would say, or the leading imperative is that we ensure that Canadians have confidence in public office holders and public institutions, and they don't seem to have that. Would you care to reflect on your time as clerk of the Privy Council? You served a Prime Minister who was found to have broken the act that we're studying, and twice found guilty of breaking that law. 10 different instances, and that's based on the regime as it currently exists. you must have some suggestions on improvements so that we can avoid a situation where we find a prime minister who is repeatedly breaking this law.
You have a minute, Mr. Warnick. Go ahead.
Sure. Well, I think we should discuss this further because the law is built on language which includes perceived conflict of interest. And I think that's always going to be a challenge because perceived conflict of interest can be very subjective. And somebody's going to have to exercise judgment about what is a perceived conflict and what are the appropriate remedies. Certainly, you can change the act to add other provisions, more sanctions, and so on. But I think the problematic part of enforcing the act is that somebody's got to exercise judgment and discretion about perceived conflicts of interest.
In the case of Mr. Trudeau, though, it wasn't a perception; it was that he actually broke the law, and it would seem that.
I mean, sorry, but you're conflating broke the law with an infraction on a perceived conflict of interest. There are many ways to break the law. Yeah, of course. But there are different remedies. Sure, but there are different remedies and sanctions available to you. Okay. And I think the committee might want to review the array and the ladder of sanctions available.
Thank you, Mr. Warnick. Thank you, Mr. Merrick. Madame.
Thank you, Mr. Chair. Mr. Warnick, I want to ask you a few questions about the Prime Minister's ethics screen. Would you agree that in terms of seeing that it is triggered, that requires an exercise in judgment that is subjective by those who are responsible for administering the screen?
I'm not sure I understand your question.
Well,
the onus is on a public office holder to provide information to the commissioner. It happens all the time.
No, I'm asking you. You earlier spoke about perceived conflicts of interest, and you specifically said that that requires an exercise in judgment on a subjective matter. Now, we have a Prime Minister's ethics screen that states that Mr. Carney may participate in discussions and make decisions affecting 100 free companies on matters that affect the company's interests as a member of a broad class of persons unless those interests are disproportionate to other members of a class. Now, I would note that this language of having a disproportionate interest doesn't come from the Conflict of Interest Act. It's a subjective question. It's a subjective test, isn't it?
Yeah, and I'm totally comfortable that that's a job that Parliament assigns to the Commissioner.
Well, the Parliament did not assign that language. That was something that was incorporated into this screen, and I would note that this language, have you seen this language in an ethics screen before? That specific language of a disproportionality test?
I think Parliament has given the Commissioner the mandate to make these judgments about what is the appropriate arrangement.
I understand we have an ethics screen in place. I understand the process that led to the ethics screen. I've just asked you a very straightforward question. It should be obvious that, yes, it is a subjective test. Yes, it is a subjective standard. And the fact that you can't even answer that, I find really astounding, and it really raises the question in my mind of whether you're coming here in good faith to answer questions. Now I will ask you this, and I hope you'll agree with this, that when we're talking about the Prime Minister's ethics screen, it's extensive. It's unprecedented. 103 different companies, 103 different conflicts of interest, 103 ethics screen, right?
Sorry, what's the question?
It's pretty extensive, isn't it? Unprecedented.
Yes, it's the most extensive private sector record since Paul Martin.
Well, thank you for providing, for the first time, a straightforward answer to a straightforward question. Now, given the fact that it is an extensive ethics screen, unprecedented, as you've conceded, Canadians have serious concerns about, frankly, the lack of transparency around it, to see that it is triggered when it ought to be triggered. And you served as the clerk of the Privy Council. As clerk of Privy Council, you were pretty busy on a day-to-day basis, were you not?
Mm-hmm.
Yeah, so can you explain to me how it is that this is being left to the clerk of the Privy Council and the Prime Minister's Chief of Staff to administer. How can Canadians have confidence that the screen is being triggered appropriately? Would you agree that there is a legitimate basis for some concern in that regard?
Well, if the committee wants to recommend disclosure of all the instances when the screen was invoked, go for it.
Well, and that's one of the problems that we have, is that right now we have no idea when the screen is invoked or not. One witness came and said that really all we have is hope and trust. Do you think hope and trust is sufficient?
No, I have my faith in the commissioner.
So your answer is that you're satisfied that hope and trust is sufficient, because that's what we have with this ethics screen.
No, those are your words, Mr. Cooper. I think Parliament has given the job to the commissioner to make judgments about the appropriate screens and the appropriate sanctions.
Yeah. Well, I certainly don't have a whole lot of trust and confidence that it is being triggered appropriately. Would you support amending the Conflict of Interest Act to provide for an enforceable general anti-avoidance measure so that anyone who circumvents the act by circumventing a technical loophole would be held accountable?
I mean, that's a question for lawyers. It would have to be linked to whatever the sanctions are for an infraction, but that's used in other laws, and you would. I don't see any problem considering it for this law either.
Okay, thank you, Mr. Cooper. Thank you, Mr. Wernick. Mr.
Thank you, Chair. Thank you, Mr. Wernick, for being with us. You mentioned not discouraging people from the private sector to join the public sector and work in politics. A political lifestyle requires a lot of sacrifice, and it's a choice that needs to be made. The legislation that we're looking to review, well, do you believe that there should be an element against discouraging people from joining the public service? Or perhaps we can include that the highest level requires the highest level of transparency. Our role is not hiring here. Yes, of course, we want to have people from diverse backgrounds, but it's always going to be a personal decision that will require sacrifice. If people have assets and they don't want to comply to a more strict legislation, well, they won't come into politics. That's it, that's all. Do you truly see that as being a problem? Is that really what our committee should be focused on? One of the goals of the legislation, and the others that I mentioned, focuses on the health of our democracy. We can have a stricter regime, and it will be costly for our democratic life. So, is democratic life only linked to individuals and their competencies? Mr. Wernick, earlier I mentioned the highest level of transparency. We need to be based on principles. One of them is that ethics requires more work than law. It's not because something is legal that it is moral. Is tax avoidance something that is moral in your view? I'm not sure I understand the question. The question is simple. Is tax avoidance something that is moral? Tax avoidance? We're not talking about tax avoidance here. Yes, we are. If I'm asking the question, I'm trying to understand how exemplary you are. It's not because something is moral that it is legal. We want to review the legislation and we want to follow our principles. Do you believe that tax avoidance is something that is morally sound? In the Conflict of Interest Act, things are clear. We talk about an appearance of conflict of interest, and yes, what is a strict barrier? The Conflict of Interest Act. And so, it's not because something is legal that it is moral. And so, there was a witness who was here last week who said to us that in order to build the trust of Canadians, we needed to focus on the matter of tax avoidance. This leads to $15 to $30 billion in losses for Canada every year. And in an article from last September, we saw that the current Prime Minister was the champion in tax avoidance. Does that not mean, obviously, that he doesn't need to be excluded, but does that not mean that we need to find a way to rebuild trust? We need to ensure that our legislation can better handle such a situation. If someone who is great at tax avoidance arrives and implements these projects that will benefit him indirectly, so an appearance of conflict of interest, and in this case we're talking about Brookfield. You believe that for democracy, transparency is less important for someone joining politics? I don't see the link with the Conflict of Interest Act. There is a way to manage conflicts of interest. Perhaps we can come back to this later, but there should be a conflict of interest filter or screen. The chair is letting me know that I'm out of time. You have 50 seconds, Monsieur Thériault. So, you were clerk from 2016 to 2019. How many times were you asked to give your advice to the Prime Minister that he needed to recuse himself from a decision? I'm not sure. It happened every now and again before a cabinet committee meeting, but I don't remember. Did the Prime Minister have to leave the room during your mandate? And if so, how many times? I don't know. And that was 10 years ago. And yet, it's quite significant. A Prime Minister having to leave the room because he cannot make a decision on that. I think you should be able to remember that. I do not, unfortunately. Thank you, Mr. Thériault.